Alrighty, this is video number 3 of the contract to buy and sell real estate residential for 2020. We are on to section 6, the appraisal provisions. So this section in here has very few items to fill in, but let's talk about them. If you have an FHA or VA buyer, again, this is very important. The heading says section 622 FHA. But this does apply for an FHA or VA loan. If you do have one of those, you do need to type in, again, the purchase price. So above in section 4, we had a $100,000 contract. This is where the $100,000 would be typed out again. Read through all of these clauses. You'll understand why, and we're going to move along for the video's purposes. Section 6.4, the cost of the appraisal. Again, you can select either buyer or seller. Very, very, very common out here in our region for the buyer to pay for the cost of the appraisal as part of their closing costs package with the lender. But I'm not saying that that is your end-all be-all. It's a negotiation point. Section 7, this talks about your homeowners association. So this is a very long and wordy paragraph. There's nothing to fill out in here, but this is what correlates to your dates and deadlines for delivery of the HOA docs, as well as the termination and why the buyer can elect or have the right to terminate. There is something to note here because we were talking so much in depth in video 2 about HOA documents and when they are delivered. There are some instances where an HOA document or documents are not delivered on time by the seller, HOA, or title company. They have added a little bit of an additional language in this paragraph here to allow for more time. So if the HOA association documents deadline is not met, buyer at buyer's option has the right to terminate, or a buyer can have basically 10 days then to review those documents. So if we pass the association documents deadline, and let's say they're delivered a couple days later, the buyer then would have 10 additional days to review those documents, regardless of the termination deadline up above. Section 8, title, record title, and off-record title. Again, very traditionally speaking, the seller will be selecting the title insurance company. So section 8.1, seller selects. If your buyer's adamant and needs to select it, or the sellers don't care and want the buyers to select it, you would select section 8.1.2. Owner's extended coverage. Since the seller selected the title insurance company, we want them to commit to OEC as well as pay for OEC. Section 8 is one of the longest sections in the entirety of this contract. There's nothing else to fill in, but there are quite a few bold letters in here, or I should say capital paragraphs. Read through there, make sure you understand what's going on. Section 9, new ILC or survey. Again, this is, make sure you have that discussion with your buyer. If they would like a new ILC or survey, you need to understand what you are going to order. An improvement location certificate is what I would say as describing as the lesser of a survey. It costs less, it's less involved, and it's more of a information gathering piece of where things are on the actual plat. A survey is just that, actual measurements, dimensions of the entire property. So make sure you understand which one you want to select. There are forms, there are different types of surveys and ILCs out there. For surveys, just for a rough instance, an ALTA survey is a very common survey that we have, but you would want to put the form of survey that you'll be ordering in there. And then section 9.1.1, 9.1.2, who orders and who pays. Again, negotiable. My stance is if the buyer wants it done, then most likely the buyer is going to order and pay. Sometimes the sellers already have it provided, but you can ask for that in due diligence, which is coming up very soon. Delivery of the new ILC or survey. It's going to be delivered to the buyer, the seller, the issuer, the title commitment, and I like to type in here both listing and selling agents, just so that way we all can have a copy and be on the same page. Section 10, So Section 10 of the contract has quite a few different things that is involved here. It talks about, the property disclosures, talks about insurance, indemnity, insurability, due diligence, and source of water. So there's quite a few things packed into here. But for the purposes of filling out the contract, this is where you would ask for due diligence documents as well as leases. So in the first video, we talked about if the property has a solar system, maybe that's leased and not owned. This is where you would include that. So selecting 6.11, type in solar lease. You don't have to be super technical in this. I like actually being a little bit more vague in this, so that way if you accidentally type in the wrong solar company, and you actually typed in more of the manufacturer who built the actual components, you don't have to worry about basically having the seller come at you and say, well, I'm not providing this document to you because you labeled it wrong. Just keep it simple: solar lease, water softener lease, and things of that nature. As far as due diligence documents goes, this is where you would type out what you're requesting from the seller. So there's a litany of due diligence documents, and due diligence documents are just that. It's anything that would pertain to the property that the seller then has in their possession. If the seller does not have it in their possession, Section 10 also protects you in that the seller must disclose any adverse material facts. So just because they might not have documentation about something they know, if they know it, they still have to state it in some manner, shape, or form. If they have the documents, this is where you would ask for it here. Myself, I have a little bit of a simple clause that I use for due diligence documents requests, and just some examples that are in here for you guys to see real quick. You can pause the video. Come on. I apologize. There's the language there. Copies of building permits, inspections, surveys, any repairs or receipts exceeding $500, any lawsuits, any insurance claims, you name it. If you can think of it, add it to your due diligence clause, and you'll start to create some overtime as you go. Again, feel free to take a screenshot of this and start to formulate your own. Section 10.7, conditional upon the sale of a property. So if the buyer has a home to sell, this is where you would put their contingent properties address that you'll be listing and selling. This is for the reference of the selling side to look up that property. Make sure that if you say it's on the market, it's on the market, and they'll look it up in the MLS. But that's where you type in the property address. Section 10.8, it's labeled as the source of potable water. But it also talks about or wants you to acknowledge whether you do or do not have a copy of the seller's property disclosure. For all intents and purposes, we do not on this, since we are asking for that document up in Section 3 in the dates and deadlines. And also you need to select here whether you know that the property is either on a well or not on a well. So if it's not on a well, select this box here. If it is on a well, you won't select this box, but you'll attest to whether or not you do or do not have a copy of the current well permit. Moving right along, there's nothing left in Section 10. Section 11, it's tenant estoppel. It's intentionally deleted in the residential contract, but it does come up in the investor contract. Section 12, closing documents and instructions for closing. The first little bubble that we need to fill out here is closing instructions. Closing instructions are a Colorado Real Estate Commission approved form. Some title companies will have their own version of closing instructions. You need to make sure and read very carefully to ensure that it is the Colorado Real Estate Commission approved form. It is a separate form traditionally executed after we go under contract. So about 90% of the time you'll be selecting are not. Very few times do you execute this as you're going under contract. As far as a closing date or I guess time and hour of time and place, Again, we don't know that yet. There's a couple different things that I've seen in the past by mutual agreement between buyer and seller. The new thing that I'm using is by mutual agreement between listing, I apologize, and selling agents. Actually, I just made a mistake. This is a good point to clarify. Whenever you are referencing either a buyer or seller in the contract, and you're referring to the actual signer of the contract, you need to capitalize the B in buyer and capitalize the S in seller. As well as when you use this, if you're talking about this is going to be designated between the listing agent and selling agent, you need to refer to the actual parties that are on this contract. So capital L and a capital S is the proper way to fill that out. Section 13, transfer of title. This is where you would select what kind of deed that you're selecting. They do have the personal representative's deed on here now. For you new agents, this was not a bubble that you were able to select before. You were able to type it in. So that's on there now. Section 15, closing costs, closing fee, association fee, taxes. Again, one of those sections where there's a lot of things and a lot of different bubbles in here. Make sure that you fill out this section correctly. This section has been one of those sections where this is the last section most people learn fully, just because there's so much involved. So let's take it one step at a time. First and foremost, I cannot agree with how they have this laid out. Section 15.1 says closing costs. Section 15.2 says closing service fee. Every single time I go to review this with a client, they believe that this is in reference to the buyer's closing costs to the lender. This is specifically talking about closing service fee to the title company. So this is the fee for preparing documents and sitting down with us at the table to get wet signatures on these places. I myself am a fan of splitting that cost between buyer and seller. As of right now, again, it's April of 2020. The highest I have ever seen on a closing service fee is $400, so that'd be a couple $100 to both sides. Section 15.3, if there is an HOA, you need to select either buyer or seller or one half in section 15.3. If there's no HOA, you're going to select none and none. Because up in the dates and deadlines section while we were filling out the contract, we are assuming that there is an HOA on this property. And I myself am a fan of holding the seller to any sort of HOA transfer fees. They can be anywhere from $100 up to, I've seen 500, 600, 700 in some cases. Make sure you know and understand what that fee looks like if you're representing either party and committing to holding them accountable to paying that fee. Section 15.4, again, double check to make sure there is or is not a local transfer tax and fill it out correctly there, and who's going to pay for that. Same with the private transfer fee. I will say that more often than not, both of these sections are marked as none, and the same with the water transfer fee and sales and use tax. Section 15.8, FERPTA, Foreign Entity Act. This needs to be selected if you do know that the seller is a foreign person. If you don't know, it's ask the selling agent. It is a touchy situation or a touchy topic, but this does need to be known because if they are a foreign person, the buyer may be on the hook for withholding some money to the IRS because of that. Section 16, prorations and association assessments. So prorations, we're talking about property taxes here in the first part. I myself select the most recent mill levy. What this does is this allows the buyer to only pay for property taxes for the time that they take possession, and it allows the seller to then prorate to the buyer an amount of money for property taxes for the time that they have lived there during that year. That prorated amount will get credited to the buyer. So that way when tax time comes and the property taxes are due, either the lender has a full escrow account to pay those, or if the buyer elects, they can pay them on their own. But either way, the buyer is getting credited for that time that the seller still lived there. Section 16.2, we don't necessarily deal with rents too often, so I traditionally leave that blank. Again, read through there. If it applies to your contract, make sure you select the appropriate box. Section 16.3, since hypothetically speaking, we are talking about an HOA fee. If there is any sort of special assessment made by the HOA, I would like to see the seller pay for that special assessment. Again, negotiation item, as if the buyer wants to pay for it to show good faith, maybe they'll get a discount on the property. Who knows? There's a lot of different negotiation tactics around that, but traditionally speaking, I would like to see the seller pay for that. You can note here 16.4, other prorations. So water and sewer charges, they're all going to be prorated, propane, interest. That's all in there. But if you have any special one-offs, this is where you would type that in manually. Section 17, possession. So possession of the property, depending upon what's negotiated upon in Section 3 of the dates and deadlines section, you're going to figure out when the buyer can take possession, but sometimes the seller's not always able to get out. They don't understand things. They maybe an amend wasn't executed to push this back. The buyer needs to charge the seller what I would call more of an inconvenience fee. So if the seller does not convey possession to the property at the time specified in Section 3, then the buyer would be entitled to X amount of dollars per day. My rule of thumb is if it's a $300,000 property, I like to ask for $300 a day. If it's a $400,000 property, I like to ask for $400, so on and so forth. There's no rhyme or reason to this, but make sure you protect your buyer, since traditionally speaking, you're going to be representing a buyer when you're filling this out. Make sure that they're covered. A hotel cost, storage fee costs. So if they need to store things, they need to move twice, those types of things, you want to make sure you kind of build that into there. Also in Section 17, this is where you would commit that you are or are not representing the buyer as it's going to be their permanent residence or principal property. If it is an investment property and they're not going to live there, you're going to want to select that box. If there is a post-occupancy agreement negotiated upon, this is where you'll select that box, just stating that it will be attached to this contract. Section 18, computation period of days deadline. This would ask if you want your dates and deadlines to fall on a weekend or holiday. Should they be pushed to the next business day? I'm a big fan of will. There are arguments on both sides of this out there. Please know and understand what you're selecting and select it appropriately. If you have any questions, reach out. Section 19, cause of loss, insurance, and damage to inclusions and services. This, in a very roundabout way, just allows your buyer to do a walkthrough at the end of the transaction process to make sure that the property is in as good or better condition than when they saw it. Again, read through any and all clauses you do not understand. Time is of the essence. So here's the next box. Specific performance. Do not ever select this box unless you have ran this by a couple different people, a couple different mentors. This box should never be selected. This can really put your buyers in jeopardy. Very few instances require this box to be selected. So do not select specific performance box. Section 27, we're almost done, guys. Section 27, this is where it states that you can have electronic signatures on things through either email, facsimile, or any other program you might be using. You can fill it in right here. Obviously, you can do a physical delivery and wet signatures as well. Additional provisions. So this is the clause box where you can add in your own special clauses. A precursor to this box is if you're adding anything in there, make sure you run things to ground and make sure you understand that you are able to practice limited law But limited law really constitutes that you're practicing more of the boilerplate sections in the contract, and that any clauses that you come up with on your own may or may not hold up in a court of law. If you are thinking of something strategic, make sure you have an attorney draw it up. Our attorney at each office has a clause manual. If you want to understand and know how to download that, reach out. Section 31, any other documents that might be a part of this contract. A very common document that you would want to type in here that's a party to this contract would be anything that requires a lead-based paint disclosure. For the system that I use, it's CTME contracts. We have a docs list. You can go and pull and select the lead-based paint disclosure form, and it inputs it right in there. This isn't a link to click on. This doesn't actually go to the lead-based paint disclosure form. It just states that it's going to be attached with this property. Anything built before 1978 needs to have this in section 31.1. If you're executing a post-closing occupancy agreement, it's already stating that you'll have that attached if that box up in section 17 was selected. And any other documents that you can think of that you might want to attach to this contract, this is where you would fill in here. Maybe a seller carry addendum, you name it, that's why the box is there. Scrolling past the buyer and seller's information, obviously fill that out to the best of your ability. But in section 32, if you're working with a buyer, you need to attest to a couple of different things. I myself do not take earnest money from a buyer as we see a property. I like them to take it to the title company or escrow holding company themselves, just so they know and have peace of mind that it was delivered. I don't like to have anybody else's checks just floating around in my car and my folders with me. Depending upon what capacity you're working with the buyer, obviously buyer's agent is highly recommended. And how are you getting paid? Traditionally speaking, if it's through the MLS, the listing brokerage firm is going to pay the buyer side. Section 33, again, if you're on the selling side, fill it out appropriately. It looks very similar to what you saw above, but read through and fill it out. Thank you guys so much. That is the contract to buy and sell real estate residential. Have a great day.